The 14th Amendment, what it says, 1868. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The original historic context, the 14th Amendment, was primarily intended to grant citizenship to formerly enslaved Black Americans after the Civil War, crafted in response to the Dred Scott decision, 1857, which said African Americans could not be citizens. The key phrase is subject to the jurisdiction thereof, and that's where interpretation becomes controversial. Traditional legal interpretation since 1898 in United States versus Wong Kim Ark, 1898, the Supreme Court ruled that a child born in the U.S. to non-citizen parents who are legally residing in the U.S. is a citizen under the 14th Amendment. This has been the basis for birthright citizenship ever since, even for children of legal immigrants or undocumented individuals. The 14th Amendment was not meant to give automatic citizenship to children of non-citizens or illegal immigrants. That the phrase subject to jurisdiction should be interpreted narrowly, only applying to those who owe complete allegiance to the U.S., like freed slaves or legal citizens. This interpretation would mean children of foreign diplomats, illegal immigrants, or non-permanent residents might not qualify for automatic citizenship. The current legal standing as of now, 2025, birthright citizenship is still the law based on the 1898 ruling and subsequent practice. No Supreme Court decision has overturned this precedent yet. However, some justices like Clarence Thomas have shown interest in revisiting or narrowing this interpretation in the future. So, my question is, how can illegal immigrants have U.S. citizen children? Well, under the current U.S. law based on the 14th Amendment plus court precedent, any child born on U.S. soil is a U.S. citizen, even if the parents are illegal immigrants. This is based on an 1898 Wong Kim Ark Supreme Court ruling, not the Dred Scott case. That was in 1861. The reasoning was the child is subject to the jurisdiction of the U.S. They are not a foreign diplomat and they are under U.S. laws, so they qualify. Keywords, U.S. laws. But here's the contradiction. The parents are in the country illegally and not citizens, yet the child receives all the rights, privileges, and entitlements of a citizen. This has led to what some call anchor babies. Many constitutional originalists and nationalists believe this was never the original intent of the 14th Amendment. The Black's Law Dictionary on citizen in early editions, such as the Black's Law Dictionary, first through early 20th century editions, the legal definition of citizen was a person who, under the Constitution and the laws of the United States or of a particular state, is a member of the political community, owing allegiance and entitled to the protection of the government. This term was historically applied to whites only. Also, the term citizen excludes slaves, aboriginals, and others not recognized as full members of the polity. This means indigenous people, Africans, and even some Asians were not legally recognized as citizens, even if they were born in the U.S. Citizenship was rationalized based on European whiteness, not just birth. So your observation is historically valid. The legal system was built to exclude non-whites from the rights of citizenship. The real issue is really two legal systems. There's a reason so many people, especially awakened Israelites and those with historical knowledge, feel this contradiction. The system was never made for non-Europeans to be full citizens. It was amended under pressure, 14th Amendment, but the root of the tree is still rotten. Even today, illegal immigrants from other nations can enter, give birth, and gain generational benefits. While the descendants of slaves and indigenous people, the true children of Yasharel, are still fighting for recognition, reparations, and justice. So what's the truth? How can a people be illegal and still pass on citizenship when those who were stolen, enslaved, and born here were told they were 3/5 of a person? Because U.S. citizenship is a political tool, not a covenantal or blood-based recognition. The original legal system was designed for white supremacy, and what you see now is a patchwork legal workaround, not a true change of heart or justice. So let me tell you my final thought on all this. The true children of Yasharel, the descendants of the indigenous people and scattered tribes abroad, were never intended to be full citizens in the land of their captivity unless Yahuwah intervenes. So while children of illegal immigrants may be called citizens on paper, the remnant of Yasharel are citizens of a kingdom not of this world, and Babylon's law will never reflect the righteousness of Torah.